Hello, I'm Assistant Commonwealth's Attorney Dan Laren, here once again with the case of the week. House Bill 463 has changed a lot of the rules on how we deal with nonviolent property offenders here in Kentucky, and Assistant Commonwealth's Attorney Aaron Matthews had a case recently with an individual who is just that. Aaron, what were the facts of your case?
The facts of this case were that the defendant had stolen 3 checks from a friend of his and forged them and cashed them. We had security video from the bank, a fingerprint from the bank, and the friend in this case looked at the security video and identified this person as the defendant.
Was there anything out of the ordinary about this case or about how it progressed through the system?
It was an interesting case. When I first received it, the defense provided a police citation from Cheyenne, Wyoming, trying to tell me that this couldn't possibly be the same person because the last check was cashed around 4 p.m. in Lexington. The citation in Wyoming showed that he was cited in Wyoming at 11 p.m. So they are trying to say he couldn't have gotten to Wyoming that quickly.
And what did the investigation reveal about the security footage as compared to the police report in Wyoming?
Well, when I initially got the video footage, I compared it to the photos of the defendant in his jail lineup, and he looked very, very similar, but I don't know if a reasonable doubt's a very, very strict standard, so I wasn't sure if it would definitely pass the test of reasonable doubt, beyond a reasonable doubt. So I contacted the detective in Lexington who had worked on the case, and he was able to actually get in touch with the Cheyenne, Wyoming Police Department and obtain a copy of their full report.
And what information in there was important to your case?
Well, after reading the full report in Wyoming, the defendant was actually stopped driving a vehicle in Wyoming. The police searched the car, and inside the car they found checks from the exact same victim that we had in Lexington. So once I provided that to the defense and confronted them with that information, their alibi pretty much went away.
So how did this case resolve?
The defendant pled guilty. He was pled guilty to 4 years, but he was probated.
Well, that's the thing about this case. This particular defendant, Matthew Johnson, is 30 years of age, and he presently has 5 prior felony convictions for theft, receiving, criminal possession of forged instrument cases similar to this one. He has over 15 misdemeanors for theft, receiving, providing a false name, and other assorted property crimes. The records indicate that he has failed probation twice, and he has been a parole violator 3 times. He was on parole when he committed these offenses, and as the case worked through the system, even though he was arrested twice in Lexington and in Jessamine County, he was given the privilege of probation once again and is, as we speak, free to walk the streets of our community. Maybe he'll get a job or go to school and change his ways, but the odds are that he will be back in the Fayette County Detention Center, where he has been booked 8 times since he was 21 years old, in the very near future. I'm Assistant Commonwealth's Attorney Dan Laren. This has been the Case of the Week.